Welcome to North Idaho Experience. In today's episode of the Judicial Watch, Eric and I sit down with Stan Mortensen. He is the chief prosecutor here in Kootenai County. For those coming from California, that's the DA, district attorney. They don't call him that here, apparently. Stan broke down the whole way the judicial system works here in Kootenai County. Super informative podcast. He's extremely knowledgeable, also a former cop. So great guy, and I think we're in good hands here as far as having a great prosecutor's office handling our criminal cases here in Kootenai County. So I hope you guys enjoyed this episode of the Judicial Watch on North Idaho Experience. We've got lots more of these to come as we dive into, paying attention to our judges here in Kootenai County, understanding how this whole system works, because they are a strong baseline for how we live our life here in Kootenai County. So hope you guys enjoy. And remember, if you're thinking about making the move, that's how we pay the bills. Our real estate team is the number one real estate team here in North Idaho, and we specialize in helping conservative families find their freedom right here in God's country. Enjoy.
That'll be good.
I have very basic questions to start out. Like, what is your official title, and what are your roles and responsibilities? I think there might be a lot of people that don't know.
Sure. I'm Stanley Mortensen. I'm the current elected Kootenai County Prosecuting Attorney. I've been in that position for 3 years now. I've been in the office for 12 years total. The first 9 years as a deputy prosecuting attorney. By law, the county prosecutor is obligated to prosecute all felony crimes in the county, irrespective of which agency arrests or investigates. We do handle misdemeanor prosecutions, and we handle all misdemeanor prosecutions by the state police and by the sheriff's office, of course. And we can handle misdemeanors from some of the cities, as long as those cities don't have their own prosecutor's office. For example, in Kootenai County, Coeur d'Alene City Prosecutor's Office, and in Post Falls, there's the Post Falls Prosecutor's Office. And so when 99% of those misdemeanors occur in those jurisdictions, those city prosecutors' offices handle those cases. My office won't see those. My office will see some misdemeanors out of those jurisdictions if they're attached to a felony.
Okay.
For example, somebody gets arrested or pulled over in Coeur d'Alene or Post Falls for a DUI, and it's a misdemeanor DUI. But as you know, when people get arrested, they get searched incident to that arrest. And if there's felony drugs like methamphetamine, heroin, fentanyl in those pockets, they're going to go to jail on the felony possession and the misdemeanor DUI. Because that DUI and felony possession are out of the same incident, my office would handle both those.
Is that normal? Is that like an Idaho thing? I'm trying to remembering back to my police career. I don't recall that. I never worked for a city though, so maybe that's why. But I feel like the DA's office in the county handled everything, and there was no prosecutor for the cities.
It just depends on the breakup of the county and the cities.
Okay.
There's 44 counties in Idaho. All 44 counties have their own county prosecutor.
Okay.
Depending on the county, there may or may not be cities within those counties that have their own prosecutors' offices.
Okay.
And even when they don't, they can contract with some of those cities. For example, Rathdrum does not have their own prosecutor's office. Under normal circumstances, the Rathdrum case misdemeanors would come to my office, but Rathdrum contracts with the Post Falls City Prosecutor's Office.
Huh. Okay.
So it just depends on the county and the cities.
Is your position the same as like a district attorney?
Yeah, that's how you can tell when people are from California.
Whoa.
There's a couple of different ways, Stan.
They'll ask me if I'm the DA. So
Okay.
if you want to hide the fact that you're from California,
Don't
don't
use
refer
that.
to me as the DA.
Guilty.
Noted.
But that's traditionally what people think my job is. My job's a little more complex than that. I'm also, under the Constitution and the statutes of Idaho, I'm obligated to provide legal assistance, advice to the county elected officials and department heads. So when the county commissioners, the sheriff, the treasurer, the auditor, the coroner, when they have legal questions, they come to my office for legal advice. And anytime the county is a party to a lawsuit, whether we're the plaintiff or the defendant, me as the prosecutor or my office it's our job to represent the county
Okay.
or those department heads or elected officials.
With that in mind, are you required in this elected position to live within the county that you serve?
Yes. I have to be a lawyer, and I have to be elected, and I have to live within the county of Kootenai.
Okay. How many prosecutors do you guys have in the office?
Sure. We're actually the
sorry, David. I know
third
where you're
biggest
going.
office in the state. Ada County and Canyon County down in the Boise area are, of course, the first two biggest offices. Kootenai County is the third. With me, there are 30 attorney positions in my office.
Okay.
So I have that divided. We have 5 positions that are dedicated to the civil realm. That's the representing the county in lawsuits, advising the commissioners and whatnot.
That was my favorite thing to say as a cop. I'm sorry, that's a civil matter.
Yeah,
that
that's
the same
true.
thing?
Yeah,
And then because I have such a robust civil division, it allows me to focus on criminal matters, which is what I like to do.
Yep.
And so with me, there are 25 criminal attorneys. So that's our division. We have 25 criminal attorneys with me, and then I have 5 civil positions.
How many cases do you guys see a year, roughly?
Well, there's a difference. There's a certain number that come in, and then there's only a certain number that we prosecute. On average, there can be anywhere from 7,000 to 7,500 cases that come in the office a year, and we're usually filing cases about 5,000 to 5,300 a year. And the reason why there's about 2,000 we don't is because sometimes we see a criminal case and we refer it back to the agency for some follow-up investigation, and that follow-up investigation might bleed over until the next year, and so that wouldn't be a statistic that we'd file, until the next year. Other times, we look at a case and we're just like, hey, we're not going to file that charge for different reasons. A lot of people forget that when the police investigate and make an arrest, they're doing that based off probable cause, which is not the lowest standard, but it's a low standard compared to proof beyond reasonable doubt. So even though my office could file charges based on probable cause, we are looking forward to prosecution. And if we feel like there's not enough evidence to convict, or there's likely going to be a suppression issue that we probably won't prevail on, we're just not going to file that charge. And so that's the reason why we only file out about maybe 5,000 plus cases a year when we're getting in excess of 7,000 cases in the office a year.
Yeah, but break that down. I mean, 25 criminal attorneys and you have 5,000 cases that you're taking forward. That's 200 per attorney per year.
It depends. We kind of divide it between felony and misdemeanor.
Right.
But yeah, my felony attorneys are handling way more cases than they should every year.
Right.
And my misdemeanor attorneys are handling way more cases than they should every year. And that's assuming we're fully staffed. I'm actually short 5 attorneys right now. I've been short more. I've been short less.
Yeah.
And so when we're already working, at capacity and when we're understaffed, yeah, we're handling a lot of cases.
How does that compare to the public defender's office as far as caseload or how many attorneys they have there?
I'm not sure anymore. About a year or two ago, they became the state public defender's office,
Right.
not the county. And so I don't get to see them that often. We're not at the same meetings. I don't hear their statistics. But the county, the state public defender's office, I don't know what their numbers are. I think Idaho distinguished themselves from national numbers, but the national public defender numbers, the recommended numbers are that no felony public defender should handle more than 150 felony cases in 1 year, or no misdemeanor public defender should handle more than 400 misdemeanor cases in a year. So what I can tell you is that nationally and statewide, for some reason, prosecutors associations have been unwilling or unable to come up with recommended prosecutor caseloads. Arguably, they should be lower. We have the burden of proof. Nothing against them. They have hard jobs, but public defenders can be kind of referred to as Monday morning quarterbacks.
Yeah.
Prosecutors, we are handling more cases than they will see because we're declining 2,000 a year. Those are cases that public defenders are never going to see. And we have the burden of proof. It's our responsibility to prove somebody guilty. It's our responsibility to have the evidence and to get it into court. Public defenders don't have to do any of that. And so our numbers should be lower than 150 and 400. And
Yeah.
I can tell you they're in excess of those numbers.
Wild.
Why did the defender's office go to the state level? Is there a good reason for that?
Because the legislature passed a new law.
It's like,
I'm not saying that's
weird.
good or bad.
Yeah,
but it was a decision.
Odd.
There was a lawsuit. The ACLU was involved. Interestingly, the courts had yet to make a decision on the lawsuit, and the lawsuit was basically along the lines of ineffective assistance of counsel. If not all counties in Idaho had their own independent public defender's office like Kootenai County had, but the lawsuit was basically alleging that some county represented defendants were receiving, inadequate representation because of the caseloads and whatnot. They had too many caseloads as well. And so before the judges even made a decision on whether this was a good claim, the legislature passed a new law, and it created the state public defender's office, and they just basically assumed everything that the county public defender's office were doing.
Have you seen a big difference, like as far as the day-to-day operations within the courtroom? Has it changed anything?
Not now. When the law first took effect, October 1st, a couple of years ago, that there were some rough patches. But right now, from my office at this point, it just feels the same. State public defender, county public defender, private attorney, it doesn't matter.
Right, and I kind of want to bring this up from the beginning. We didn't give you an opportunity to say who you were and how long you've been in that prosecutor's position, but you're the head prosecutor of Kootenai County in Idaho. Idaho was just rated as the lowest crime in the country. We're ranked 50th out of 50 as far as crime rate. So obviously, and you guys have a really high caseload. My question for you, in and out of court every day, what is the biggest challenge you guys are facing right now?
Right now, our staffing levels and our caseloads.
Yeah.
I've had 7 attorneys quit this year, and most of them have quit because of either pay and or the caseloads. Just in the last several months, I've lost 3 of my attorneys to Bonner County. They are a smaller county, yet they pay more than I do, and they handle less cases than I do. And so it's very tempting for my attorneys to not have to move, and they can just travel a half hour, 45 minutes further away and make tens of thousands of dollars more a year and handle less cases, sometimes half the caseload.
Right.
How is Bonner County paying more?
I don't follow their budget cycle. I've heard that with the 3 I lost recently, they each got $10,000 signing bonuses. One of them received about a $6,000 increase in their salary from what I pay them. The other one received about a $15,000 pay increase, and the third one received about $21,000, and that's on top of the $10,000 signing bonuses.
Wow.
And I can tell you, with 2 of those, I had just given them raises. I had just given them about $10,000 raises, and yet they still were able to make more money going to Bonner County. And again, they handle fewer cases than we do. Traditionally speaking, I've lost a lot of attorneys over the year, and so did my predecessor. And we're hiring good people, excellent people, great prosecutors. About half the people that quit the office stay in prosecution, and a percentage of them not only stay in prosecution, but they join on with Coeur d'Alene, Post Falls, Spokane, Bonner County. They're making more money, and they don't even have to move. So we're being very selective in who we hire. We're finding the right people who want to prosecute. We're just losing them to some of the surrounding jurisdictions.
It's probably pretty common. I feel like that's what it was like where I worked is it's a bit of a training ground. People realize either your heart's in it for the job, or it's a training ground, and then you're going to go on to private practice or something where you can just make more money.
Yeah, you learn a lot of experience as a prosecutor. I remember right out of law school, 2-3 years out of it, my fellow classmates were like, how many trials have you done, and how often are you in court? And, I can be in trial every week if I want, or at least once a month. I'm in court every day. Talking to them, they've been an attorney for 3-5 years, and they've only been in court once or twice, and they haven't handled the trial. And so, you get a lot of experience, and you get that experience very quickly. Some attorneys only want to be a prosecutor for a couple of years because they want to get that experience. And as a private attorney, you can bill $300, $400, $500 an hour. Some people only want to be a prosecutor for 10 years because that's when your loans can be forgiven. So as soon as you're debt free, you hit the private sector, you can make a lot of money. And so statistically speaking, it's very hard for me to keep a prosecutor beyond a certain point.
And I think that's natural attrition. I think that's probably built in to, that particular within the Kootenai County Prosecutors Division, you're going to have people that leave or that go on to federal prosecution. But I had the same argument with the Kootenai County Sheriff's Office when I was there. You have to at least be competitive with the other people that are in your own arena. And what you don't realize is that you hiring a great person right out of law school and finding good talent is not going to replace a prosecutor that's been there for 5 years. It takes a year, 2 years, 3 years to spin up.
And that's just it. One of those three that left for Bonner County, they had prosecuted for 25 years in Los Angeles. And they'd been in my office less than 2 years.
Right.
And so, when somebody's been a prosecutor for 25 plus years and you're replacing them with a new law school graduate, as good of a hire as that is, because we vet them, there's a lot of people we say no to. A new prosecutor right out of law school versus a 25-year career prosecutor, it's not the same.
Yeah. Well, and I think you have an interesting perspective. You were what your job was previously, when we can look at that, and then also look at prosecutors as a new cop. It takes you 2 years, 2.5, 3 years till you can kind of handle just about everything on your own. Not perfectly, right? But to where you're a good, serviceable deputy. I said, so if you're trying to replace them with somebody straight out of the academy, that's not a one-for-one swap. And which one do you want showing up to your house? In your guys' case, which one do you want prosecuting your case? The one that's been there for 10, 15 years. You have to remain competitive. And that's the argument that always frustrated me with like the BOCC, because we had that conversation when I was at county. Is you guys think this is a one-for-one swap, that this is plug and play and you're plugging in a body. But you guys are going to pay on one side or the other, right? And I always said, if you have 2 one-year deputies walk into a house and they make a quick decision, tense, rapidly evolving, and then it goes on for 2 years and people decide that they may or may not have been able to yield a more favorable outcome, right? You're going to pay it on the back end.
Yeah, I'm losing over half my prosecutors before they hit their 5th year.
Yeah.
I've hired over half my criminal prosecutors in the last 3 years. Fortunately, though, I've had a few prosecutors stay in the office a long time. I've got one criminal prosecutor who's been in the office over 20 years. I've got another of my prosecutors who's been in the office over 10 years. I've got a handful over 5 years. And fortunately, these people are amazing people. Their hearts are in it, and they are directly responsible for training some of my newer attorneys. So not only are we vetting the law school graduates we hire, and not only are they very bright and capable people, they're being trained by some of the best prosecutors I've ever worked with. And so I'm very fortunate, despite the fact that we're understaffed.
So attrition's definitely an issue. How about anything else? What do you guys face like in the courtroom? What's unique about Kootenai County? What are some of the challenges you guys face in your day-to-day?
Well, we have 17 judges in Kootenai County. We have 17 courtrooms. We have 14 judges. We have 9 magistrates and 5 district judges. And so, we're in court almost every day. Every day and every hour we're in court. That's just less time we have to do the paperwork, do the research, write and file the briefs. And so we're just always on the run.
What's the difference between a district and a magistrate judge?
In Idaho, magistrate judges, criminally speaking, they handle the misdemeanors, and the district judges handle the felonies. Magistrates do handle felonies within the first few weeks of the case. They handle the preliminary hearings. So they're kind of like the gatekeepers into district court for felony criminal matters. And they have civil responsibilities as well, whether the case is above or under $10,000 and whatnot. But as far as the criminal law goes, our magistrates generally handle the misdemeanors, and the district judges handle felony matters.
Okay. Is there do they get to the district level by having time in the job, or?
Talking about how judges get their jobs?
Yeah. No. The district ones, are they a higher level because they're handling the felonies? Is there any difference there, or is it just, do they have like more years of experience generally? Is that
they will, yeah.
Yeah, okay.
So a magistrate has to have at least 5 years as an attorney before they can be a magistrate judge, and a district judge has to have at least 10 years as an attorney before they become a district judge.
Okay. Do you guys have investigators, DA investigators?
Yes, my office has two full-time.
Not DA investigators. What do you call them?
Where are you from? My office has 2 full-time criminal investigators, and we have 1 part-time.
They sworn, I'm guessing?
Well, they're sworn under my office.
Okay.
Currently, 2 of my 3 are post-certified. 1 is retired California law enforcement, not Idaho post-certified, but the other two are sworn, not just as a prosecutor's investigator, but they are actually post-certified officers.
Okay.
All right, so we're getting into it now. So we've talked about magistrate judges, district judges, and you were saying, how are they? Can you explain for the folks, because we've done it on our previous judicial watches and probably butchered it because it's me trying to explain it. I'm not in the attorney's office. How is somebody selected as a magistrate judge?
Well, first there has to be a vacancy. Vacancies can come about because somebody quits, retires, dies, or they there's a new position created. And so once there's a vacancy, somebody will apply. Again, there's different criteria. That, there's an age. You have to be a minimum age. Not only do you have to be an attorney for 5 years, I think the last 1 or 2 years have to be in Idaho. And they also have to live in Kootenai County or the county that they're chambered in. But the magistrates are selected by a magistrate commission, and that's a group of people. I don't know if it's 12 or 15 of them. And there's lawyers and non-lawyers and some judges on that committee or on that commission. And they receive the applications, they vet them, and they interview a portion of them, and then they select one of them.
Okay.
So when they get selected, how long are they judges before they go back up for re-election?
Sure. I think the magistrate judges will be on the elections in November. Not maybe this November, but they're in the November elections, and they're every 4 years. And I think they stagger them. So maybe half of them will be 1 November, and then the other half will be 2 Novembers after that. And they're on the ballot every 4 years. But you can't run against the magistrate. The voters have the option of either retaining or not retaining that magistrate. So if 51% of the people say yes, then the magistrate continues to have a job. If 51% of the people say no, the magistrate doesn't have a job, and then we'd go through the selection process.
Right.
But the public has no part in the initial selection process.
Correct.
Okay. And so they can only say, so that person gets selected by this commission, and then once their 4 years are up, then we can do a yes or no.
They might be on the ballot with it, before 4 years.
Okay.
But it's like I said, it's kind of a 2-year cycle. Some will be on it 2 years, and then the next 2 years later, but a total of 4 years. So, for example, if I became a magistrate today, I might be on the November election in 26. So I'd be on the ballot before I hit 4 years, but after that first election, then I'd be on the ballot every 4 years after that.
I think this is what
Something
initially got me annoyed with the voting system and was a catalyst for starting this, at least from my side, was seeing the names on the ballot and the yes or no. And I'm like, well, what the hell does this mean? Like, why?
Right.
What is this? You can't find any information about it.
I was going to ask if you were going to give advice to citizens out there that want to stay involved and keep our community the way that it is and just want to be informed for the election, where can they find information about our current judges, and some of their rulings, or, where can they find any of that information, or even who's up for re-election?
Well, most court hearings are open to the public, so the public is always welcome to come into court and watch. Very frequently, whether it's one newspaper or the other, there might be an article about what happened in court. Not with all cases, but with some of the more serious cases, I'll do a press release and I'll put it on Facebook. And so there's a few different ways the public can stay involved.
We appreciate that, by the way. I'm big on full transparency. I mean, it is a matter of public record, and anybody that's making that type of decision in a courtroom should be able to stand behind that decision. And it's not to say they're good or bad. I've seen it go both ways. They just are what they are. Allow the public should know, especially on big cases. I think that's kind of what motivated us in the first place. Because I'll tell you, I asked that question hoping there'd be some magic website where I could go on and see, judges who's up for re-election and then see some of their decisions and see if it aligns with my values before I go vote. But I can't find anything like that. In preparation for the first Judicial Watch episode, I couldn't even tell you who was running for re-election this May, because we haven't got into district judges yet, but they come up in May, right?
Yeah. Just real quick about the Facebook page.
Yeah.
It is about transparency, and it's not just the judges. It's about me. I'm transparent. My office is transparent. When I do a press release, I don't put my opinions into it. It's just what happened. the public can make the decisions. I tell people, hey, Joe Schmo was sentenced for this crime on this date. 1 or 2 sentences about the facts of the case. I'll tell you the possible punishment for that crime. For example, felony DUI is a maximum of 10 years. I'll tell you who the prosecutor was usually, who prosecuted the case. I'll tell you what the prosecutor recommended, and then I'll tell you what the judge did. So you're getting 3 numbers in my press releases, because just to hear that the judge gave 5 years, without any perspective, that doesn't mean anything to anybody. So, I want you to know what the maximum sentence is. I want you to know not just what the judge did, but what my office recommended. Maybe you think my recommendation was too light or too strong. Tell me about it. I'm accountable to the people as well.
I wish it was that way across the board, because there was a very recent one that was released, and it was the one, of course, Trooper over here lost his mind with 7th DUI. And
I was just thinking about that.
Yeah, he saw
I heard DUI and I thought of that one immediately, and I was like, yeah, I lost my mind about that. That's crazy.
Because you post what the recommendation was and what the sentencing was, and understanding there's context that we're probably missing somewhere. But it is tough, but it does give people a pretty good perspective. I just wish that transparency was passed along so that people could make an informed decision when they go vote. My concern is that people just look at it and say, well, Idaho's a really safe state. We have a really low crime rate. Everything must be great. All the judges must be great. And then they go and they have no idea. I just want them to be informed when they vote. I think that part's important.
What's the real quick, what's the name of the Facebook page?
I'm not on Facebook.
Yeah,
okay.
Yeah.
My office does it. So it's Kootenai County Prosecutor's Office.
Okay.
Or Kootenai County Prosecuting Attorney. Should be a really ugly picture of me on there.
Well, I'll try to find it and link in the show notes so people can jump on there if they want info.
Yeah.
But that's very helpful to the public just to have that available.
Yeah, and see it as it comes out. I mean, North Idaho News definitely reposts it whenever KCPAO puts it out, but it's good to have it straight from the source and have that interaction and transparency. I think it speaks volumes about the office itself. Can you break down district judges for us, how that process works?
They also have an age requirement. I can't remember what it is. They have to be attorney for at least 10 years. I think the last couple in Idaho as well. And of course, there also has to be a vacancy. But what happens with the judges usually is there's a vacancy and there's going to be a governor's pick. So there's an entity called the Judicial Council. So an attorney who meets those qualifications can apply to be a district judge. They'll apply to the Judicial Council. The Judicial Council will receive the applications, will vet them, and then they'll interview a portion of those applicants. And then the Judicial Council, that's also made up of attorneys and non-attorneys, they submit a list of names to the governor, usually at least 3, I think. And then the governor picks one of those 3. After the Judicial Council gives the governor their list, the governor will actually interview those candidates, usually down in Boise, and then the governor will pick who becomes the next judge. However, the district judges are also on the ballot every 4 years. They're not split up, every other November like the magistrates are. I think all of them are going to be on the ballot every May. So, and I think 2026 is the next election for them. So all of the Kootenai County judges will be on the ballot in May, and it's a primary election. There's nothing in November. And unlike magistrates, attorneys can run against district judges. Usually nobody runs against our judges, so they're usually on the ballot alone, but they are technically able to be run against. And of course, if they get more than half the votes, then they keep their jobs.
So if someone, say they had information about this judge and they knew they did not want that judge in there, we don't need to use names, obviously, and they come up on that ballot, the best thing they should do is just don't, right? It'll be a bubble and one judge if no one's running against them. If they don't like that judge, just don't vote, right?
That's certainly an option. I'm not going to tell anybody
what
to do.
Yeah, you don't have to, but
vote with your conscience and do the research you've done.
I'm saying that is an option. You just don't fill out the bubble.
It's always an option.
Yeah, okay.
The other thing, too, is depending on what time of the year or what time of the 4-year cycle a judge retires, when there becomes a vacancy, there may not be a governor's pick. There just may be an election. I'll give you an example. 3 years ago, when I became the elected, my predecessor, who's now a judge, Judge Barry McHugh, he retired from the prosecutor's office. He announced Well, first he announced his candidacy to be a judge. We had a judge, Judge Haynes, retired or announced his retirement. And the timing of his announcement meant there was not going to be a governor's pick. There was going to be an election. So Judge McHugh, former Prosecutor McHugh, he filed to run to fill Judge Haynes' vacant seat. Well, nobody else filed. So Judge McHugh ran unopposed. And so Judge McHugh was not a governor's pick. So governor's picks are not the only way to become a district judge. It's the more common way. But you can run against the judge, and you can also run for an open seat. And if you get lucky, you run unopposed.
It's weird.
It is. It's
just like anything else. You know? I mean, if a president or a commissioner or a mayor ran unopposed, you'd do the same thing. Yeah.
I totally get that. It just I'm trying to wrap my brain around the governor's pick.
I just
logic.
feel like that's just nonsense because he's going to spend 2 minutes with these people. Yeah, I'm sure somebody slides him a name. You know what I mean? Like, you don't have to comment on this, I know, but it's me and Eric talking.
Yeah, but
it seems weird.
Yeah, because you get to that position, you tend to bottleneck your sources of information.
Yes.
So you trust a lot of the people around you, the couple of people that are advising. But I still go back to the same thing. As a voter, I can't find any information.
Well, so I can tell you that the process, they vet them really well. They send a survey around the state for all lawyers and judges to fill out. And so you're getting ranked by your peers. I mean, there is a very tough process to go through. So by the time a name gets to the Judicial Council and then the governor, they've been vetted pretty well.
Fair.
Yeah, and recently, too, the legislature just passed a new law. If a judge retires or quits a certain way that creates an election, the legislature wrote a new law and passed it. That judge who's retiring will get $25,000.
Oh, so they're encouraging the election.
It seems to me like the legislature is trying to encourage an election rather than a governor's pick.
Yeah. Okay.
And I can't speak for the legislature.
I
I don't know what their motivations or intentions were, but that's the reality of this law. Is that some of these judges are going to be quitting or retiring anyway, and they have to decide. Well, am I going to quit? And is there going to be a governor's pick, or am I going to quit and there's going to be an election and I get an extra $25,000?
Huh. Okay, I'm a fan. I just say, as a tax-paying citizen, I support that because I think I prefer an election. I guess that's where I was bringing it up. A governor sits down in Boise, right? They're in Ada County. I'd prefer that people are here that actually have a voice or pay attention to what's going on locally, have an opportunity to elect their next district.
I do like that, but why didn't they just do legislative that got rid of the governor's pick and only, you know what I mean? And save the taxpayer $25,000 for whatever. But hey, it's moving in the right direction.
It's a step in the right direction.
Well, and hey, it also leaves open the possibility that a judge could quit in a way so they secure that $25,000.
Yeah.
And then nobody files to run for that seat, so you have nobody on the ballot for that May election.
Yeah.
I think then it would be a governor's pick again. So
interesting.
Traditionally, for whatever reason, there just are not a lot of lawyers who are going to step away from their practice or their job and run to be a judge. Usually they're going to be applying, and I don't know why that is, but just because the legislature may be trying to do one thing doesn't mean a lot of judges are going to do it, or maybe there's not going to be a lot of elections. I don't know.
Maybe that probably goes into answering my next question. It sounds like it's hard to get practicing attorneys to put in anyways, even if it's pick or unopposed. But how often do we have challengers to incumbent judges?
Well, as you know, I have been in the criminal justice system here for the better part of 25 years. I was a sheriff's deputy for almost 8 years before I went to law school here in Kootenai County at the sheriff's office. And so in my 25 years here, I think I only remember seeing maybe 3 attorneys run against judges. I was one of them. I ran against one of our judges 3 years ago. So aside from me, only 2 other times that I can remember. I could be wrong, but it doesn't happen often. Far more people are going to be applying to fill a vacancy when there's a governor's pick.
Interesting. So with that said, are you aware of any circumstance in your 25 years here locally where an incumbent judge was defeated?
No.
See, checks and balances, bro.
This is a tough hill to climb.
Yeah, and you can see why when you actually learn the process. And I just think there's a void of information out there. So you said there's 14 judges. Were you say are all those magistrate judges?
There's 9 magistrates and 5 district judges
Okay,
in Kootenai
that's right.
County. Of course, we're in District 1, so Shoshone will have their own judges. Bonner, and Boundary have their own judges.
Yeah.
Even Benoit has their own judge.
Who are the 5 district judges right now?
You have Judge McHugh, you have Judge Pittman, you have Judge Simmons, you have Judge Cafferty, and you have Judge McCree.
God, and they're all up for re-election in May.
I believe so. Well, Judge McCree is new. That I haven't read it myself. I've heard there's some law out there where a brand new district judge within the first so many months or years, that they're not going to be on that next election.
Yeah, they have like a grace period or
So,
18 months or something.
There's a strong possibility only 4 of our 5 judges will be on the May ballot.
Got it. Wild.
Well, yeah. What are, as a chief prosecutor, what are the traits that you look for in a judge that you want to see in a judge? Does that make sense?
I want somebody with a lot of experience. I would prefer that the judge have been a trial attorney. It's the same thing with a lawyer, a prosecutor. I want somebody in the courtroom who's going to understand the rules of evidence, the general things like that.
Mm-hmm. Or like consistency, is that a big one?
Yeah, consistency. That's a pretty big topic.
Mm-hmm.
At prosecutors as well, I have a lot of discretion as a prosecutor in what I do with my cases. There's a lot of judicial discretion as well. I can tell you we have 14 judges, and even when you're in front of the same judge consistently, lawyer, defense attorney, prosecutor, judge, every case is handled on a case-by-case basis.
Okay.
So you couple that with discretion, and there's a lot that could happen.
Is it reasonable to ask as interested citizens of the community that there is some standard? I agree that there's going to be human discretion, and every case is different. It is case by case. But I always think you should be able to apply the same logical pattern in regards to evidence and elements of that particular case and have pretty standardized results, even if it's different judges. Is that reasonable or unreasonable?
Well, you do for the most part. The rules of evidence are the rules of evidence. You really can't deviate from them. Of course, with certain applications of those rules of evidence, there are analysis that must be gone through. At the end of the day, it's the judge's decision whether or not evidence comes in or whatever ruling is given. But within that, as structured as it is, right? You have the rules of evidence, you have the analysis by case law. There's still an element of judicial discretion.
Yeah.
So, I've seen the same judge kind of do something different, in one case compared to the next. Of course, you're talking about a different defendant, different set of facts. Mm-hmm. Every case is handled individually. Prosecutors, we receive a lot of the same crimes. We'll give a certain plea deal in one case and maybe not in the other. And so there's just a lot of things that could be done different in different cases. It's all within the name of discretion.
That's fair. And I think Seth intentionally brought up consistency. That was a big part of my motivation. Mm-hmm. I was local law enforcement. I was in your office often, several times, in preparations for motions to suppress on occasion. But I was there a lot. And for a lot of us on the ground level, and there's lots of things that go on, it seemed like one of the number one factors in whether or not a case was prosecuted, even similar elements, which is the judge that was assigned to the case. And that's where it's like, okay, different interpretation, I agree, but there should be lanes where it's fairly steady and consistent. Mm-hmm. I think that should be a desire, without removing the human element, because I think discretion is important, but there should be some consistency, in my opinion.
Yeah.
From my perspective. As a prosecutor of Kootenai County, I was going to ask this before, do you guys get rated, or do you guys get evaluated in comparison to prosecutors in other counties? Do they kind of gauge? Do they watch perform? Do you guys get a report card, if you will?
No, we have to keep our license active. Mm-hmm. We have to take classes. We have to take 30 hours every 3 years. If a prosecutor wants to become a judge, then we'll get kind of that survey around the state. We'll be kind of ranked by our peers, so to speak. But under normal circumstances, no. You're going to be evaluated by your individual bosses, right? So I've got 29 attorneys under me. I evaluate my own attorneys, but nothing outside of the office.
Okay.
This just popped into my head. who are you under? Are you being an elected official, or like, do you answer to anyone?
I answer to the voters.
Okay.
To the public.
That's it. I like that.
How did we end up with the Clark decision? And I want to preface it with
This is a big one for you.
yeah, well, in the state of Idaho, law enforcement can no longer arrest on misdemeanors that did not occur in their presence, unless they've got a willing citizen that can do a citizen's arrest.
That is such a huge deal. I arrest a ton of my arrests in California were misdemeanors. Not they were all DUI, DUI related, but that was incredibly useful for me.
Oh yeah, well,
And it got people off the street that needed to get off the street for the night. You know what I mean?
Right.
Like that was the big one. And I think the DV side of it, which you dealt with a lot more,
yeah,
is the same thing, right?
yeah, and that's why I'm curious. Just through the process, realizing that it can go from a county and then it goes to the state legislature. How did we end up with that? And then how do we, address it? How do we fix it?
Sure. So what happened? I'll start at the beginning. In I think 1890, Idaho became a state. Right. We have our own constitution, and there's a lot written in our state constitution. Among the many things written in our state constitution are police powers. When can an officer arrest? And so it's written in our constitution essentially that an officer can only arrest for misdemeanors when they have occurred in the officer's presence. When it comes to a felony, the felony doesn't have to be committed in your presence. So what happened is over time, several decades ago, the legislature passed a law closer in time to the Constitution being, ratified in the state of Idaho that kind of mirrored the Constitution. So you have the Constitution describing when officers can arrest, and you also have a state statute. And they were identical. Over time, statutes get amended by the legislature. And one of the statutes that was amended many years ago was when officers can and can't arrest. And many decades ago, the legislature said that officers can also arrest for misdemeanors outside of their presence when it's like domestic battery, domestic assault, no contact order, violation of a protection order, stalking,
Yeah.
And so, ever since then, there were a lot of situations, usually domestic violence, where, officers are going to get there after the fact. Very few times is an officer going to be present when one spouse is battering the other, right? So you're there after the fact. That means the crime did not occur in your presence. Well, officers were making arrests in those situations in reliance of that amended state statute. Well, several years ago, when a gentleman by the name of Clark was being prosecuted by my office, a defense attorney in town, a public defender, was reading the Constitution, and he said, hey, this statute is very different than the Constitution. And he made a motion to dismiss. One of our district judges denied it. I opposed it as well. And it's like, well, we've been doing this for a very long time, and we're doing it in reliance of the statute. And the judge dismissed it, and it went up on appeal. And the Supreme Court disagreed. The Supreme Court said that essentially what happened, and the Supreme Court's right, I know it's a tough pill to swallow, especially for us in law enforcement, but what happened was the legislature amended the Constitution, but they did it improperly, right? So when the legislature wants to pass a law, let's say there's 100 congressmen and women. How many of those congressmen have to vote to approve that new law? 51, a simple majority. Well, what does it take to amend the Constitution?
I don't know.
Supermajority, right? You're usually talking about 2/3. Okay? And so what happened was when Congress passed that new law amending the statute, giving police more powers, what they did was they amended the Constitution, but they didn't have the proper amount of votes. So if we want to go back to the pre-Clark days, what has to happen is our legislature has to not just pass a new law, they have to actually amend the Constitution.
Is there a push for that, or does some poor woman have to die before that happens?
Yeah, it's going to end up being
100%.
Yeah, Melissa's Law or something.
I don't know. I don't know what the legislature's doing. Clearly, they haven't done anything yet. But, there's still options, right? Officers are still able to respond to those calls. They're still able to investigate them. They're still able to charge. There's a lot of charging options. You can cite and release somebody. You can talk to your victim or witness, whoever witnessed the crime, and they can do a citizen's arrest. And you can also call a judge and get an arrest warrant. You just can't make the probable cause arrest without one of those two things.
One, what inevitably ends up happening is officers go to a domestic and they find probable cause that's a misdemeanor, and then they have to leave them there, encouraging them to separate for the evening.
That sucks.
Yeah, it sucks.
Well, sometimes still on scene, or maybe you back out of the house, you stand on the street corner, you call your judge, you get a warrant, you go back in, 10, 15 minutes later with your arrest warrant too.
Right.
But there's a time period where, possibly those two are left alone in the house before officers can take action.
Did you guys ever have DUI not committed in your presence?
Hold on, you're giving judges a lot of credit for how fast those arrest warrants can come out. Having sat on SWAT calls for 6 hours.
Well, the domestic warrants and the DUI blood draw, they happen a little faster than most
good.
warrants.
That's good to hear.
Yeah,
that is because that is the short term. I wish the legislature moved faster. I mean, I'm always going to end up bringing up fentanyl at some point, but we finally got fentanyl trafficking for the worst illicit substance our society's ever known. We finally got trafficking, which is the drug statute with the most teeth with minimum mandatory sentencing. And it took us how long? I mean, it was up a year ago is when we got it, year and a half, 2 years ago. So I wish they'd move a little faster. I don't want it to have to be a Melissa's Law, right? That it actually garners attention at the legislature.
It affects more than domestics. As you mentioned, you've seen it in the wintertime, not just the wintertime, but primarily in the wintertime. You'll see a slide off where a drunk driver loses control of the vehicle because of the weather conditions. They slide off on the side of the road, they hit a telephone pole, whatever. By the time the cops get there, they're already out of the driver's seat wandering around, right? And so you can stop and investigate that person, keep them from leaving. You can make them or ask them to do the field sobriety test. You can offer them a breath test or a blood test. You can still charge them with DUI, but unless you have an officer who saw them behind the wheel, you can't arrest them.
Right.
Because the crime didn't happen in your presence. But that doesn't take away your ability to stop and investigate and charge somebody.
Yeah.
They just might be, leaving with a citation and a taxi or an Uber rather than in handcuffs to the jail.
Right. We had, I love articulating stuff. I had a lot of fun. I think I was a thorn in
I bet you were very
side.
good at it.
Oh, yeah. But it was similar because you have to get a little bit more creative with stuff. I had something very similar where it was a DUI crash and then fleeing the scene of that crash. And I was able to locate that individual. And in my mind, that's still in my presence. They're still in the act of fleeing the scene. Right, because it was
one
within,
continuous act.
Yeah, it was a
Well,
continuous
then we're
act.
talking about a different crime, right? If they're fleeing you and you say, hey, stop, you're under arrest, and they resist or obstruct you, now the resisting, obstructing has happened in your presence. The DUI hasn't.
Right.
So you can take them to jail for the resisting, obstructing. They're going to get a citation for that.
Yeah.
But you've got to give them a citation for the DUI. You just can't book them on that charge.
Right. It's wild because when you think about either way, it's a misdemeanor citation. Either way, it's a misdemeanor crime. What you're talking about is the custodial arrest because everything else is done the same in the courtroom.
Right.
You're right. Like it doesn't change the sentencing or potential.
The thing with
sentencing.
DUI is like sometimes that initial night in jail is the worst thing they're gonna get out of it. So it's like I don't want to like short them on that. I want to make sure they get that opportunity.
Or worse than that, they call a friend and come pick them up and then they drive again.
Yeah, that is the worst.
Call your
scenario.
legislature.
I'm with you, man.
Get them to amend the Constitution. That's the way things work.
That's what we're trying to do here, buddy. That's what we're trying to do.
Question about crime trends since the time you've been at the prosecutor's office. I want to say DA's office so bad. Prosecutor's office. Have you noticed different crime trends, overall?
I don't look at percentages, so to speak. I look at how many cases come in the office. Obviously, I can tell you 12 years ago when I was in the office, it seems like between Memorial Day and Labor Day, that's those 6 months. There's a spike, and then in the fall, winter, and early spring, things are a little slower. Anymore, it's just we're busy all the time.
Like, have the types of crimes changed over time? I guess that's what I'm getting at. I mean, more drugs, more DVs, things like that.
The vast majority of our cases are related to substance abuse, whether that's the actual charge or not. The majority of our cases are going to be possession, whether it's marijuana or fentanyl or anything in between, that and or DUI, right? However, I can tell you that most of the domestics we see, one or both parties are usually intoxicated, and most of the thefts we see, somebody's stealing to support a habit. So whether it's possession, DUI, some kind of theft, or crime of violence like domestic battery, substance abuse is a factor.
That harkens back to what you always say of like hitting him on the front end.
Man, well, you'll hear me. You've heard me rally about drugs before because it's hard. It's hard for me to catch somebody burglarizing your car. That's luck. Right place, right time, right moment. But to catch somebody with the dope that prompted the theft in the first place, that's something that you can affect. And that to me is part of that. You can thwart a lot of crime by being proactive. And obviously our cops out here are pretty proactive because you guys get a lot of dope cases.
We do. And, drug offenses are not victimless crimes. I know I'm speaking to the choir here, but, these are people who are usually going to become addicted if they're not already addicted. These are people who are not going to have jobs, or they're not going to keep their jobs very much longer. And, we oftentimes are in the home, not prosecutors, but I was a cop, and you go into a home and there's a toddler with a dirty diaper because the parents can't afford new diapers because they're spending money on drugs. The toddler's crawling all over a pile of syringes. And, there's meth on the floor over here and heroin on the coffee table over there. And so these children are being neglected or abused. They're entering the system. We're spending tax dollars and resources and CPS hearings. And people, when they don't have a job, they can't pay rent or their mortgage, they lose their home. Then you've got homelessness. And, drugs are not a victimless crime. It affects society on so many levels.
I agree.
And so, a lot of us believe that if you can intervene early, sometimes with criminal charges, maybe you can force somebody to get treatment and maybe their lives will be a little bit different early on.
I'm still amazed, and I still stay in touch with some folks that I ran into when I was on patrol and having got themselves cleaned up. And they said the best thing that happened to them was getting arrested. The best thing was an intervention, right? At some point where they ended up with enough skin in the game to distance themselves from that habit and that crowd. I used to say it all the time on patrol. Look, I don't want your child growing up without their mother, but if she's not going to be sober, then I will, right? Then I'll do everything. You can't be in your child's life like this, right? Yeah. That's way too dangerous for them. And I appreciate those built relationships, and it's wild that sometimes it's the stick. It's the stick that makes you puts enough skin in the game to get you right.
Well, two things about that. So I've grown up with people who died to drug abuse. I had a cousin die from drug abuse. I've had friends, I've had neighbors, I've gone to church with people who have lost a loved one to drug abuse. And I can tell you that 100% of those people would rather be visiting a jail cell than a gravestone. So, it is what it is. Yeah. The other thing is, too, I shop, and I've been in stores before. And usually when somebody gives me a funny look at Walmart or Safeway, it's because I've bumped into them through my career, and it's usually not a nice look. I've had a few people kind of accost me in public, wait for me, catch me off guard or follow me. And, they end up making contact with me. And I've actually had a few people thank me. They've told me, hey, you were my prosecutor. You sent me to prison, or you did this or that with my case, and you're the reason why I'm alive, And so prison's not for everybody, but sometimes that's what it takes to get somebody clean. Yeah. So I've seen it all.
Yeah. Well, I think withdrawal, when you're talking about, fentanyl is a totally different thing than we've had before, but that withdrawal is so bad. And I've fought with people that were trying, it was less fighting me and more fighting the consequences, fighting the withdrawal that's coming. But if that's pushed on you, you're never going to want to go through that again. I've talked to several that said, I did that. That was the worst I've ever experienced. I'm not doing it again. That motivating factor of you were forced clean because you were in jail, right? And then you get back out and you don't have to do it again. That's a motivating factor. Speaking of, can you give us a quick rundown on riders? Those come up quite a bit. I know that with sentencing, just what that means.
Sure. So rider, R-I-D-E-R. That's what we're talking about, right? So we're talking about felony cases now. Again, our judges have a lot of discretion. Most of our criminal statutes do not have mandatory minimums. And in Idaho, we don't have sentencing guidelines, okay? So, for example, felony drugs, it's punishable by up to 7 years in prison. And so, the state's going to come in and recommend one thing, the defense attorney is going to recommend another, and the judge is going to do maybe something else, all in the name of discretion, right? But generally what it is there's generally two options, right? The judge can put somebody in prison for up to 7 years, or the judge can put them on probation, suspend the prison sentence. There's a third option that's called a rider. The proper name for it is called a retained jurisdiction. And that's because it's all about jurisdiction. When the case is pending and all the way up until sentencing, the judge has jurisdiction over the defendant, right? The judge can make them appear in court. If they don't appear in court, the judge can put them in jail. So the judge has control over these defendants, jurisdiction over them. If the judge sends somebody to prison, the judge is relinquishing their jurisdiction and giving it to the Department of Corrections, the prison system. So if somebody goes to prison, the judge can't touch them anymore. Now it's the prison guards, the warden, the parole board if they get out. And if they violate parole, they don't go to the judge anymore. They deal with the prison system and the Pardons and Parole Commission. Probation is the exact opposite. If somebody's sentenced for a felony, but they're kept on probation, the judge keeps that jurisdiction, which means if they violate prison, the judge can pull them into court, usually because we get a probation violation report from the probation officer, but the judge has jurisdiction over that person still. A retained jurisdiction, it's a law, it's under statute. The judge can put somebody in prison for up to a year and still retain their jurisdiction over that person. And during that year, it's usually 3 to 7 months, maybe 8 or 9, they're going to be in prison, they're going to be getting treatment in prison, but the judge keeps jurisdiction over them. And so inside of that year, the person's going to come back to court for what we call a jurisdictional review hearing. The judge is going to read about all the good and or bad things they did during that year prison treatment program, and the judge is going to decide, okay, now what do I do? Do I leave you in prison and relinquish my jurisdiction, or do I retain my jurisdiction and keep you on probation? And so however many months they're in prison getting that treatment, and the treatment depends on why you're in jail or prison, right? Drug addicts and alcoholics are going to get different treatment than a wife beater or a child molester. Mm-hmm. Okay, and so the prison treatment is going to be tailored to the individual. Whatever it is, the judge is going to decide, now do I keep you and put you on probation and keep my jurisdiction over you, or do I relinquish my jurisdiction and let you serve the rest of your sentence in prison? And so that very complicated process that we call a retained jurisdiction, for whatever reason, we call that a rider here in Idaho.
Mm-hmm. So is that like that to me sounds like it, if somebody that hasn't been in a bunch of trouble before, is that like a one-time thing?
No, you can go on more than one rider. I've seen people go on 2 riders within a year. Like I've seen people go on a rider, right? And they can be there up to a year. They're usually going to come back within 6 months, give or take. I've seen them come back with a very bad report from the Department of Corrections saying, hey, this person's not participating, they're committing rule violations. We'll come into that review hearing and we'll say, hey, judge, it's pretty clear this person should just stay in prison. Well, the defense attorney, the defendant are going to say, well, I've still got 6 months left before my year mark. Why don't you just leave me down here and let me try to finish this thing? And so essentially they get a second bite at the apple. They'll come back into the review hearing and they could get probation. I've even seen people over the course of many years of probation in the same case do 6 or 7 riders. Oh, wow. So you're talking about somebody who's been sentenced. They might get probation up front. They might go on a rider up front. Either way, they're coming back and they're being put on probation. So they're coming into court on a probation violation. The judge could put them on a rider. When they come back and they're put on probation again, if they violate probation, the judge could put them on another rider. And so I've seen people violate probation essentially 5, 6, 7 times.
That seems very burdensome.
Get repeated riders.
Yeah. It seems very burdensome on the system and on you guys and even judges.
Yeah. What is your opinion as the chief prosecutor? Do you like riders or no?
It's good to have as an option.
Okay.
That there's value to a rider. So again, it's a case by case analysis.
It seems, and this is outside information. I'm talking to some of the guys at the Kootenai County Jail. It seems like Kootenai County in general has a far higher percentage of riders than other counties in the state. Is that accurate?
I've heard that somewhere. I think Kootenai County has a high volume of riders compared to the rest of the state. Whether that's half or not, I don't know.
Yeah, but
I'm not I'm not a big fan of doing the same thing multiple times, expecting a different result.
Yeah.
Some people call that the definition of insanity. But I've recommended more than one rider for a person over the years. Sometimes I think somebody should only get one chance at a rider. Sometimes I don't think somebody should get a rider at all. They should go straight to prison. Again, it depends on the circumstance.
Right. Yeah, I wanted to clarify that because I didn't even have a full...
Yeah, that's good information.
Well, just, again, it seems burdensome. I mean, it's back in court, back in court, back in court, back in court, and then even kills me when somebody violates probation and they're out, and then they can go right back on another rider. I didn't realize that from patrol level, but it makes a lot more sense why they got out so fast afterwards.
Right.
Or I had to see him again.
Can we go back to something you mentioned earlier, sentencing guidelines? Why don't we have sentencing guidelines, and do you think they're good or bad?
It just depends. That's your typical lawyer answer. It depends. The federal government and a lot of states have sentencing guidelines. Idaho doesn't. To answer your question, why don't we? Well, it's because the legislature hasn't mandated it. Whether they're good or bad, it depends on how you look at it. Even within sentencing guidelines, the judges still have a lot of discretion, right? And my understanding of sentencing guidelines is, let's say we're looking at a crime where the possible punishment is up to 20 years. Right. Well, in Kootenai County, because there's no sentencing guidelines, the judge could give 1 year, the judge could give 20 years, the judge could give probation, the judge could put them in prison. When there's sentencing guidelines, it just kind of narrows it down a little bit, So you still kind of have a high and a low. It's just there's some guardrails there. It's not quite 1 to 20. Maybe it's 8 to 15. I don't know.
Okay.
And of course, it depends on the person. The person, their age, their criminal history, the facts of the case. Everything is going to be taken into consideration to kind of get that low point and high point, and then the judge still can kind of act within those boundaries.
Okay.
So here's the standards and consistency I was talking about. That way you don't just have such a wide gap.
And we don't have sentencing guidelines, but some crimes we do have a mandatory minimum. There are a few of them out there. Primarily, we're talking about first-degree murder, and we're talking about drug trafficking. If somebody's convicted of first-degree murder or drug trafficking, probation's not an option. They have to go to prison for at least that mandatory minimum sentence that the statute calls for. If the crime, and most crimes don't, but if the crime doesn't have a mandatory minimum, then anything's on the table, including probation.
Okay.
Wild. And that's the other part of this. I mean, sentencing is such a huge part of what draws a lot of the public attention, but what I try to bring up here also is that has to survive everything else just to get to that point, right? Like your prelim, your motion to suppress, reduction in charges, whatever that looks like, before you even get to a trial. And then you get proof beyond a reasonable doubt, and then sentencing comes up. So there's a lot of judge's discretion the whole way.
Or a guilty plea, but yeah, there's more than one way to get a sentencing. But yeah, you're going to be in a lot of hearings. There's going to be probable cause hearings, sometimes two. There's potential motions to dismiss, motions to suppress, like you mentioned. And then if it goes to trial, it's up to the jury and whether or not the state met their burden.
Wild. What's your take on probable cause hearings? Other states, I always had this question as a cop. If I sign a probable cause affidavit and submit that to a judge that then looks at it, reads it, based on what's written and signed and attested to by me as the arresting officer, they say, yeah, I find there is probable cause, and then we have an additional probable cause hearing. It's not like that in all other states. What's your take on that?
Well, in Idaho, we're usually having those probable cause hearings and felonies, but you're right. The officer is going to have their probable cause affidavit. The judge is going to see it and find probable cause. But within 2 weeks, we're going to have a preliminary hearing, and that's a probable cause hearing. At that hearing, me as the prosecutor, I actually have to call witnesses and put on evidence.
Oh, yeah.
And so, what you're asking is, why are we having a hearing where the state has to put on evidence to find probable cause when the judge has already found probable cause?
Seems redundant.
Well, the reason why we do that is because it's the law.
Fair.
Not all states have that. Idaho clearly does. So that's why we do it.
I'd just love to put some numbers to it, again, as a citizen, because I have a different perspective now. I mean, I was in court a lot, and preliminary hearings were a huge burden. And I tell cops that are coming here from other states that are lateraling, you're going to court here. Like, you're going to go to court because prelims, they don't go often, but they go a lot. I mean, it was regular for me to be in court once per week. I mean, that was pretty... Yeah, that I could almost bank on that, depending on when that was happening. But again, it just seems redundant to me if they've already established probable cause. And I know that that's a state legislature thing, but I'd love to put numbers to the amount of overtime paid by citizens, or calling in witnesses, or the burden that it puts on you guys?
Well, as a cop and as a prosecutor, you're going to be in a lot more preliminary hearings than you're going to be in trials.
Right.
Yeah. So most of your courtroom time as a felony prosecutor, you're going to be in a preliminary hearing way more times than you're going to be in a trial.
Right.
Even our grand jury system is different. There's a lot of jurisdiction in the country where grand juries work differently than in Idaho, where, I prosecuted for a year in West Virginia, and you might have 30 cops or 30 witnesses in a case, but at the grand jury, I can have one officer who can testify about what everybody else did, and then the grand jury decides whether or not there's probable cause. Here in Idaho, we have to follow the rules of evidence. I can't just have one of my witnesses testify about what everybody else did. I have to call all those witnesses in to explain to the grand jury what they did and why. And so it's just the way Idaho operates.
Well, and I've seen that. Maybe you can provide some clarification. It's my understanding there was a case that was a child victim, and the child was required to testify in this state because they have a right to face, the accused has a right to face their accuser, I guess, in this case. But they put up COVID times, and they put up a wall in the courtroom. Are you familiar with this one?
I don't remember if it was COVID times or not, and I don't remember the case, but I think I know what you're talking about. So, a defendant who's been charged has the right to confront their accuser, their witnesses. And so whether it was COVID or not, I don't think it was. Basically, when you have a child victim who's been molested by their father or anybody else, under normal circumstances, you wouldn't drag that 5-year-old kid and put them face to face with
crazy.
their, abuser. And so, lawyers get creative sometimes, and it's like, well, what does the right to confront your witness mean? And so I think what happened was, it's bad enough the child and the perpetrator have to be in the same room within 15 feet of each other. Let's just put up a barrier so that they can't make eye contact, right? They're in the same room. You can still feel the presence. You can even hear the voices, but you're just not making eye contact. And so we got a conviction in that case that went up on appeal, and the Supreme Court said that violated the defendant's right to confront their accuser. And so, we had to do that case all over again.
This is where
what are you supposed to do there?
Not put up the barrier, obviously.
That is insane to me.
That's the part that gets me fired up. I've done my best to not be opinionated here today.
Yeah.
Okay, but I
That
just
one gets me.
We talked about it at our last podcast, and you don't have to give any opinion on this. I just want you to know what came out of this when we were talking to somebody. I said, what do I have to do every time as a witness before I come in and testify?
You have to swear to tell the truth, the whole truth, nothing but the truth.
Right. Did I take an oath when I became an Idaho peace officer?
We all did.
We all do, right? So I come in and swear that I'm going to truth, whole truth, nothing but the truth, so help me God as a witness. Why don't judges have to swear an oath when they come in?
Well, they swear an oath when they put on the robe.
Exactly. I don't know. That to me,
just one time.
But I'll tell you, there
At
is
least that time. I don't know how many more times.
Right.
I literally had a note right here, there, because I was going to bring that up too.
To me, because I'll tell you, when you come in as a witness and you raise your right hand and I'm on the record, it's like,
well, the oath that judges take is a little different. They don't swear to tell the truth, the whole truth, nothing but the truth. They just swear to uphold the Constitution and the state.
I'm with that.
Yes, we had the thought of because
but the judges aren't testifying in court.
Right.
So
but they are
oath.
expected to, maintain consistency, have certain
follow the Constitution. Yeah.
So we had this thought of would this be a good idea to have legislators put that up as a new law, that every time a judge presides on a case, that they have to do a short oath as well. Just a little reminder in the back of their mind.
Reaffirmation, because I can tell you as a cop, I gave that. I took that oath when
it kind of keys you in. All right.
Oh, it does.
Not that you don't tell the truth every other time, but
a subtle little reminder of what it is that actually governs you, which is your constituents.
Well, I take the oath, and I take it once, right? Yeah. How many more times do I have to take it? Yeah. Right. Whether it's me or the judge or anybody else, there's a lot of people in the courtroom that don't take their oath as many times as a witness or a cop might, right?
Right.
Or swear in anyway. And so, I think that the fact of the matter is that the legislature authorizes it, then it's going to happen.
Yeah. Oh, I get it. I just when I think about that one with that child victim, Do you remember why you became why you became a judge in the
To
first
protect
place?
the innocent, right?
Yes.
Are we doing that right now?
Follow the Constitution, but obviously there was some articulation made by the prosecutor, but like sound judgment and virtues have to become a part of this as well.
Well, as a prosecutor, and if I'm speculating here, but right, if I was a judge, I mean, I'd like to think that once is enough, right? I mean, I don't feel like I need a reminder of the oath I took, and I would imagine that judges probably don't think they need a reminder either. I take my oath very seriously. I'm sure the judges do as well.
Yeah.
So 1 oath, 10 oaths once a year, I don't know. Is it?
Yeah. Well, I just like it. I like the idea of because when I come in and I swear, and not that there's ever any intention to do anything else, but it's just like plugged in. Okay, all right, here we go.
I'm on the record.
Yeah, absolutely.
Yeah.
To me, I don't mind the reminder, and this is just me talking, especially when you get judges that have been judges for a really, really long time. I think it's really easy to lose perspective. I think it's easy to lose touch with what's going on at the ground level. I don't mind like a reaffirmation here and there of what they're committed to.
Yeah, that and having judges, I don't know, quarterly go on a ride along with a cop. What's a drug house look like? I mean, you know what I mean? Like that's important. If they've been a judge or I don't know, 20 years, like when was the last time they set foot in a house and saw what actually? I mean, they see pictures, I get that, but you don't get the smell.
Yeah,
And all of the other senses that get involved.
Well, and I think you said it before, and I don't think it's opinion, but drugs are not a victimless crime. And I think you see things a little bit differently from the lens of, walking into an overdose death and, a young child has been with her mother for the better part of 18 hours deceased in a room, right? Like that's not a victimless crime. I think that perspective is important.
Yeah.
Right. I think maintaining that. And I just think it's like a lot of other jobs, it's easy to lose that perspective.
We're just talking. You're being quiet, which
Yeah,
makes
yeah,
you think
yeah.
you don't want to say anything. That's fine.
No.
That's fine. He's pleading the fifth. Yeah.
You haven't asked me anything.
No, you're right.
that's
You're
fine.
right. We're just spitballing. You're
I
right.
know. No, truly, it's we really appreciate you having come in. I know you're crazy busy. I know that
Heck
you're
yeah.
slammed. I know that there's interest in this, and I also want to say, I'm on mental health for first responders on the Red and Blue Foundation. I don't think prosecutors get enough credit for what they have to see and deal with.
Same stuff.
I mean,
really.
they're
Yeah.
forced to, some of the videos they're forced to watch, and some of those interactions. I appreciate the job they do. I don't want in particular that she handles more than her fair share of those investigations, and they suck. And appreciate the work that you guys do. And again, I don't think you get enough credit for some of the crap that you have to deal with. And I cannot imagine having to sell the parents of that child on testifying in front of their abuser. And I know other states don't have that. I hope that Idaho can adopt some of those.
Well, I can tell you, we didn't get into it a whole lot, but plea deals, right?
Mm-hmm.
A lot of times people think, they pled the case out. Why are we doing plea deals? There's a lot of factors that are taken into consideration when my office extends a plea deal. And you're right. Sometimes the parents do not want their 5-year-old child to take the stand and have to testify in front of their accuser. And sometimes the parents are telling us, I will not let you put my kid on the stand. Am I going to issue that parent a subpoena and make them do what they don't want to do?
No.
I have that power and authority, but do I really want to use it that way? Sometimes that's the reason why we give a plea deal, and just because there's a plea deal doesn't mean somebody's not going to prison. Maybe it's just less time than they would have. But, there's a lot of reasons why we give a plea deal. And sometimes it's because, the victim or their family's position on things.
Right.
And getting a plea deal and a reduced charge or a reduced sentence is better than an acquittal or a not guilty verdict. Because if I can't put my witness on the stand or I get them on the stand and they clam up, I'm going home with a not guilty verdict.
Right. I totally get it. I don't, and that is a lost part. A lot of people don't see that or understand the inner workings of what happens, and it's not like you can post that, right? Like
exactly, that's the stuff that people just don't find out. Those are usually hearings that are behind closed doors. Those are conversations that are had in my office and not in open court. Those are things that the paper's not going to pick up on, and I'm not going to put in my press release.
Right. Do you think Kootenai County in general, and we'll just talk about that in North Idaho, but Kootenai County specifically, do you think they would benefit from some sort of, I guess you'd call it like a judicial watch or judicial review, where people can more readily access information about judges when they're up for re-election and what some of their rulings are?
I mean, information's never a bad thing. I guess
Yeah. No, absolutely. No, I agree. I think an informed population is an engaged population, and the more engaged our population, the better off we are. And that wasn't with the intention of saying, oh, we need to out a whole bunch of judges. I like the idea that people have a place where they can go learn, right? Where they can learn and then make an educated decision when they're in the voting booth. Our community's still small enough that can make a huge difference.
Yeah.
Well, I can tell you it would take a lot of effort. Like I said, there's the newspaper. People can come into court. There's my press releases. Most people aren't going to be able to come to court because they have jobs. The newspaper doesn't and can't report on everything. I can tell you, I post a press release maybe once a week. Sometimes I skip a week. Sometimes there's 2 or 3 a week. If I did more press releases than I already do, I'd get nothing done, and so I average one a week. That's 52 a year, 52 press releases a year when I've got 5,000 cases a year, right?
Yeah.
Yeah, we're not trying to put this effort on you, by the way.
No, I'm just saying that even if a group or the member of the public wanted to come into court and do something, it's a daunting task.
So we are fortunate in that we have an army of retired cops up here that would love nothing more than to come sit in on court cases.
A lot of them are going to call you the DA no matter how many times you tell them you're the prosecutor.
100%.
Well, we all know what we're talking about.
Yeah.
So, we've had quite a few reach out that want to get involved. So we are standing up an official Judicial Watch here shortly. It'll probably be a nonprofit and have its own LLC and the whole spiel. But that is the goal, is to put citizens in the courtrooms just to observe. Like, obviously, we don't want anybody saying anything or doing anything. Just observe, take the facts. We'll take the facts and then we'll disseminate it to the public and let the public decide. We're going to try to be very unbiased, as best as we can, nonpartisan. Just doing what you're doing, but trying to do it even on a larger scale, because we know you guys don't have time. And
and you have a lot more rules than we civilians.
True, we don't have rules.
Well, and again, just remember, my press releases aren't just about the judges. It's about what my office is doing, right?
Of course.
Right.
There are plenty of times, not as many as the other way around, but there are some times where the judges give more of a sentence than even my office recommends, right? And if you think that my office didn't recommend enough, then hold my office and me accountable. So,
well, and you guys do, man. It's I'm sure it's very rewarding, but it can be a very thankless job because half the times the victims don't want you to prosecute, right? Depending on what the circumstances are. Their families are hard to deal with. Dealing with accused, dealing with defense attorneys is tough. Dealing with judges can be really tough. And then dealing with cops that are pissed that you're not going to take their case is tough. One of them may be sitting in here, you know what I mean? But
I don't know if it's half, but it certainly happens.
Yeah. But honestly, I've never had an encounter with you where it wasn't completely altruistic in intention, where you said, here's why. And I'm like, I don't have to like that, but I completely respect that. And a lot of time it's looking out for us, or looking out for the betterment of the, totality of the circumstances. I never got that feeling with you at all. So appreciate what you do.
Yeah.
Honestly, I mean, it is a difficult job, and in an area where we get, as citizens, we get rewarded as having one of the lowest crime rates in the country. You play a big role in that.
Heck yeah.
I appreciate it. Thank you for having me.
Yeah, that was fun.
Like I said, your willingness to be transparent as a parent, because you came on here with us. I don't know a lot of people that would, which is cool. Your counterpart on the other side, I didn't even get into. I don't think you have to live in the county of Kootenai to be the public defender on the other side. I'd gladly have him on.
I'd gladly have him on if he's interested. Maybe he'll listen to this.
Well, the state public defender, the main one, I think does. But you're right. I mean, there's, my understanding is there's the state public defender, and then there's the district public defenders under them. And then sometimes the county will have its public defender, even though they're not county, they're still state. So, for example, you got the state public defender down in Boise, and he supervises all 7 districts. We're in District 1. District 1 has a District 1 supervisor, public defender. I can tell you that that public defender does not live in Idaho. Under the district public defender, there's one of those public defenders who runs the Coeur d'Alene office. They don't live in Kootenai County either. And so you're right. Most public defenders are not required to live in Idaho, but I think the main state public defender does.
It's because I guess, and the only way in my brain it makes sense is it's not an elected position.
It's not.
Right.
And a lot of my prosecutors don't, live in Kootenai County either.
Right.
But I do, the elected.
Yeah. Yeah. I got you. I don't know that one. I get my brain
bugs
twisted
me a little bit for some reason.
Well, just because you can have such a huge impact
And
on
you're not vested in
the local
the
community
community.
here.
Yeah.
But
Well, hey, that's what the legislature's for, right?
absolutely.
Yeah.
Well, and that's what we're trying to drum up enough interest and at least pass the knowledge out to the voting population.
Yeah.
Truly, out here, our community's still small enough to where you can make a difference with the way you vote. So,
Well,
all for it.
thank you, sir. Much appreciated.
Thanks, Stan. Great to have you on.
Yeah. Later.
Bye.